The Constitutional Court has been examining whether South Africa's current laws on sexual consent violate victims' constitutional rights to dignity, equality, freedom and security. The case stems from a High Court ruling last year where the accused was acquitted after claiming that he thought the victim had consented even after she asked him to stop. So, at issue is the controversial legal defense that allows rape-accused suspects to claim that they believed the victim had consented even if that belief is unreasonable. So when you look at what happened today in court, Advocate Nasreen Rajab Butler SC has urged the Constitutional Court judges to rethink how intent is assessed in these sexual violence matters. Well then, let's talk further then about this. Bring in Leanne Germanos, who is the co-founder and director at Embrace Project. Leanne Germanos Manuel, good to have you on the program, Leanne. Thank you for your time. Let's put in context the importance of this case going all the way to the country's apex court.
So, like you mentioned a bit earlier, and by the way, good evening to all your viewers as well, there was a rape case that was heard before a magistrate actually in 2018, which resulted in the acquittal of an accused person. And it was that case actually that sparked our constitutional challenge as the Embrace Project, which was instituted in 2022. That case actually came as a result of the second applicant in our constitutional challenge, who was the rape survivor in the 2018 rape trial, which resulted in the acquittal. It was her story and her experience of the criminal justice system that actually triggered this response from us as the Embrace Project and resulted in us approaching the court. In her case, the magistrate found that there was unlawful sexual penetration without the consent of the second applicant, but she just could not convict the accused person because she said that even though he wasn't a credible witness, the state wasn't able to prove beyond a reasonable doubt that he had subjectively intended to commit this rape because the second applicant had not outwardly resisted, essentially.
And on that then, how clear at the moment, because the High Court has already pronounced on this matter, how clear are the rules around consent, right? Because I remember a few years ago when we were dealing with rape cases where victims and lawyers were having to explain that consent can be withdrawn at any point in the sexual encounter.
Absolutely. It can be withdrawn at any point, and it must be obtained for every different and new sexual act. So there were two issues really that were argued before the Constitutional Court. It's not just the issue of consent, but actually also the issue of intent. And this combination and the manner in which intent in criminal cases is tested becomes problematic. Also then when you combine it with the definitional element of consent. So, for example, in the second applicant's case, there wasn't an issue with proving that the second applicant herself had not consented, but there was an issue with proving that the accused knew that. And it's that combination that becomes really problematic because the state can prove beyond reasonable doubt that there wasn't consent, but that's not enough, according to our Sexual Offences Act.
So how then would this change get rid of, for want of a better phrase, that grey area?
So what we are proposing is that an objective test be used when it comes to testing intent with sexual offences. And we say that because we believe that there is a violation of victims' rights to bodily integrity, safety and security, when you are able to rely on just the subjective state of an accused person's thought process when it comes to obtaining a conviction or an acquittal. And the reason we say that is because the way the law currently is structured and stands, it actually perpetuates rape myths, and it also encourages, or rather accused persons with more perverse, problematic views around sex and sexual consent have a higher chance of being acquitted on the basis that they subjectively didn't understand that there was a lack of consent. So we are suggesting the application of an objective test And what we did in the High Court, in which the High Court agreed with us and granted, is we asked for a declaration of constitutional invalidity of all of the provisions in the Sexual Offences Act, where consent is an element, and of course intent is an element. And then we asked that while the legislature fixes this issue with the law, this issue with what we call an unreasonable and wrongful belief in consent, we suggest that there be a reading into Section 56 of the Sexual Offences Act, which is the defense part of the Act. And we ask that if an accused, while the legislature is fixing this problem, wants to raise the fact that they believed that they obtained consent, they must show that they took reasonably objective steps to ascertain that consent. They can no longer rely on the absence of, they can no longer rely on the absence of resistance. They now have to actually take positive steps in order to ascertain consent.
Briefly then, pardon me, Leanne, we're just almost out of time, but I want to get this into the conversation briefly. Do you see an opportunity here then for rape victims, for instance, who in the past may have had cases against their abusers fall through the cracks, to bring those back, or has that ship sailed for them?
Unfortunately, in our law, with criminal law, it can't apply retrospectively. So for persons, not only for persons who have had their cases fail or not even be prosecuted because of this very issue that I'm talking about, but persons who have been sexually violated before the law changes won't be able to even use the new law, unfortunately.
And is there even telling, when you look at just the volume of sexual violence cases that go through our courts, how many, especially women and others, mainly women, right, because those are the main targets of sexual violence in this country, how many would have suffered an injustice as a result of the law in its current phrasing?
So, I mean, if I can give you an example, a statistic was used during today's hearing, and it was also used during the High Court hearing. Out of the number of rape cases that are reported to the SABC, which is an average of about 40,000 a year.
Leanne, my apologies, I'm so sorry. I'm told we have to leave it there because the President has just started speaking, but we'll have you on later, I promise, for a much longer conversation, especially once the Constitutional Court has made a decision. But my thanks to you for your time this evening.